Crime.
To the Law News Network, everybody. That was earlier testimony today in the John Valerio case out of Las Vegas, Nevada. The defendant there accused of murder and convicted of murder for a crime that happened 31 years ago. The conviction was 29 years ago. They're retrying him on the death penalty phase. LawNewz's Cathy Russon is here with me to help break things down for you over this lunch break. Cathy, it's good to see you again. It's been a little while on the air, at least.
Good to see you too, Aaron.
So we've got this case. It's an old case. They have to retry it because the Ninth Circuit Court of Appeals turned around and said that the penalty phase wouldn't work because the original wording of the law, the jury instructions, was too vague. And so here we are again. It looks like they're going through things a lot more efficiently than I perhaps predicted the other day. They've had to, at least early on in the case, I should say, because we've got people who are now retired detectives, but I don't think that either of these guys that I've seen thus far have missed a beat. They seem to remember everything very, very clearly. They are up to date on what's gone on in the case. I don't know if they've been given a chance to look at their notes or not, or if this was just such a huge case at the time that they remember it so well.
Yeah, one of the detectives did say he reviewed his notes and maybe previous testimony yesterday. So they definitely are trying to get up to speed. But yeah, I mean, this detective that's testifying right now acts like he just barely investigated this case.
Yeah, but it sounds like he was involved in the finding of some critical evidence. I mean, he's talking about the victim's body. He may not have been there for very much of it, but he seems to have been there for some critical parts.
Yes, so the first person we heard from today, he did regular patrols in an area where they would find a lot of stolen vehicles abandoned, and he just happened to be doing a regular patrol through there and called in the license plate number of a car, and it came back, and it was the victim's car. He saw her leg or foot and high-heeled shoe when they opened up the trunk. So after that, he called in everyone else, and they started their crime scene investigation.
Yeah, I mean, well, that's how it started. So then we get into some of what we also heard this afternoon here, and I thought that it was an interesting hour there from about 3 o'clock to, about 3:45, an interesting 45 minutes, because right at the top of the hour when I sat down, we start hearing about this shooting where the defendant's driving his car at these officers who had sort of cornered him in a cul-de-sac. So he looks at them and I guess starts heading right straight for them. Apparently they felt their lives were in danger because then they open fire on him, didn't hit him. He gets away. They then track him down at his friend's house. And then from there they transition into this discussion about search warrants being executed on his home, and that's when they found all the critical evidence. They've got blood, they've got car keys, they've got the address book. So, I mean, this guy runs to his friend's house, makes no attempt to try to clean up the crime scene. I mean, I don't know if this, you can tell that this is a case from 31 years ago because most of these cases that we cover these days, things are a lot more sanitized. Apparently criminals are trying to outsmart the DNA and all the other science these days.
Yeah, well, what had happened was they originally, they found addresses in the victim's book. Now, the testimony we heard today was the victim, Karen Blackwell, was a prostitute. When they went and interviewed her husband, now he just called husband, he didn't say ex-husband, but they've also mentioned her having a boyfriend and being an active prostitute. I'm not clear if she was still married at the time of her death, but when they interviewed the husband, he was very forthright with the police. He told them that her chosen, as they worded it, her chosen profession was a prostitute, that she was very meticulous in her record keeping of her johns, of the men that she was with. And that's how they had so much information up front. And then the husband handed over the wives. At some point, they got the victims what she called the trick book, and that's where she meticulously kept notes of the men that she saw. And the names, she would use different aliases with these men, and so she would keep track of what names she used with what men. Well, that's how they ran across the name John Valerio and his address.
Yeah, I mean, it's a lot of old-fashioned detective work, much different than the sort of cases that we usually watch here on LawNewz. So what I thought was originally going to be a case that surrounded unavailable witnesses, perhaps people who couldn't be tracked down, perhaps officers who in theory, could be dead. I mean, if they were investigating this case late in their career, they wouldn't be available to testify some 31 years later. But we've got officers on the stand who are now retired, but they seem to remember this really, really well. And rather than a lot of confusion about getting people actually to testify, it just looks like more and more like, at least from my perspective, a history lesson into the way a crime was investigated back at the time that this happened versus the way a crime now would just involve so many forensics elements. I honestly don't know if anybody these days would be found to have an address book. I mean,
and we saw it twice. She had this trick book, and the defendant had an address book where he wrote, like, look, I remember my mom having an address book, and she wrote down everything in there. And John Valerio had that, which they found the victim's name and number. Now, a name, an alias name, but they matched that up to the name she said she used when she would take notes in her trick book with her actual phone number that they knew was her phone number. They did some good, they did some spot-on detective work, because when they found the car, I tweeted out a picture. There was special gravel that was found in the floorboard of her car, and they noted that. And when they went to the residence, where they were going actually to a next door neighbor of his, so this is very interesting. And when they went to walk away, they noticed that same type of gravel in front of Valerio's home, which they didn't know who he was at the time. So they went ahead and just knocked on the door. And that's how this kind of all started rolling, about how they found him. Then they backed it up, and with her trick book was able to match him with that address and her notes on him. But it kind of started with gravel on the floorboard of her car.
Yeah, this is a lot of circumstantial evidence to start with, which then just leads to a chasing of a paper trail. Like I said, it's just like old-fashioned detective work. These days you'd probably have, no address book. You'd have somebody trying to delete cell phone records. So then you'd have to get the cell phone expert in, or somebody to testify about pulling the data out of the phone. And then you'd have the cell phone tower people saying, well, the phone may or may not have been in the area, depending on whose scientist you want to listen to. And then, that type of gravel can be found in 50 million other places, according to the quarry that mines it. And it just would keep going on and on and on and on and on in that sort of direction. But when this happened, people were carrying around paper address books and making calls on rotary phones, and that's ultimately what led police to the defendant here.
We also heard today the horrific, they showed autopsy photos, which of course we didn't air, but the jury saw autopsy photos and heard descriptions of the number of stab wounds that Karen Blackwell had. 45 stab wounds. And the important part of that testimony that was at least pointed out by the prosecution was that several of them were grouped. They called them groupings in clusters, like 8 in a row at the back of her neck, and then another like 8 or so under her left breast. And they were grouped. And the detective testified that in his experience, that means those particular wounds meant somebody wasn't fighting back, because they were very close to each other. They weren't like torn, didn't look like any movement was going on at all. And I found that, the whole thing is disturbing, but then you think she's not moving at that point, and he's still stabbing her.
Yeah, it sounds like just an absolutely horrific scene, a horrible case, but the guilt phase stuck, so we're at the penalty phase. I want to listen to some more of the testimony from this morning, and we'll be back in just a bit with you, Cathy.
Thank you.
Please state your name and spell your first and last name for the record.
My name is James Charles Vaccaro, Vaccaro.
Go ahead. Sir, are you currently employed?
No, I kind of do handyman work and automotive work for my family. Unemployed job though, no pay.
Are you retired?
Yes.
When did you retire from?
The Las Vegas Metropolitan Police Department.
When did you join on with Metro?
In September of 1977.
If you could sort of go through, give us sort of the course of your career.
I went into the police academy in 1977 and I graduated in January of 1978. I became a patrol officer and was a patrol officer until 1980 when I tested for a position as a SWAT officer. And I got that position and was there for 4 years. In 1984, I tested for a position as a narcotics detective, and then I got that position, and I was in narcotics from 1984 till almost 1994, 10 years. Then in 1994, I became a homicide detective after testing, and I remained there until I left the police department. I retired in 2007 after 30 plus years, so it was 14 years of homicide.
During your time in homicide, how many cases do you think you investigated?
I was involved in hundreds of cases during that time. I never kept track of the exact number. I know I was on in excess of 400 to 500 death scenes during the course of my career, but hundreds of investigations were assigned to me during that 14-year period.
Now, I'm going to direct your attention back to sort of 1986.
Yes, sir.
In September and October of 1986, were you what we call TDY to a particular assignment?
I was.
What does TDY mean?
A temporary duty assignment. I was, at that time, as I said, in 1986, I was a homicide detective. And I temporarily, for 3 months, went to our general assignment detail, which are detectives that are first responders to major crimes. And they evaluate the situation and then call in the specific detectives, such as a robbery or a homicide detective, depending upon the type of crime that you first respond to.
In September and October of 1986, as part of your temporary assignment to general assignment, did you have involvement in the investigation and ultimate arrest of John Valerio?
Yes, I did.
You see Mr. Valerio here in court today.
Yes, I do. He's seated to the far left of the table I'm facing, next to Mr. Vitero.
May the record reflect the identification of the defendant.
Record also reflect.
Now, you weren't in homicide at this point in time, that's correct?
That's correct.
Do you know who the lead homicide detective was in this particular case?
I do. There are two detectives that are familiar to me. One's name is Tom Dillard, and the other one's name is Bob Leonard.
When you joined homicide, were either one of them?
They were still.
And so you've worked with them?
Yes.
Now, were you requested by me to sort of review a variety of information in this particular case in order to sort of summarize the investigation into the murder of Karen Blackwell?
Yes, I was.
Let's talk about what you had at your disposal to look at. Did you have the police reports associated with the Karen Blackwell investigation?
Yes.
And that investigation, did it have what they called a DR number back then?
Yes, it did.
What's a DR number?
In those days, it was called a DR number for daily report. It was a number that started with the year that we were currently working in, and then numerically, the events of that day would trail on, so if the first call of the day would be 0001, and so on and so forth, and then each day would reset during that time period.
And in this particular case, was there a unique identifying event number so you knew the reports you were reading were associated with the Karen Blackwell?
Yes.
Did you also have an opportunity to review all the photographs taken under the same DR number, both at autopsy, the various crime scenes, the crime lab, and everywhere else?
Yes, I have.
Were you all provided trial transcripts and other transcripts associated with the prosecution of Mr. Valerio in 1988?
Yes, I was.
And did you also receive information as to a prior robbery committed by Mr. Valerio in 1983 and a battery with a deadly committed by Mr. Valerio in 1986?
Yes, I'm aware of both of those.
And finally, were you also, did you find within the electronic file provided to you photographs of Karen Blackwell and Summer Blackwell and one of Roger Blackwell in real life?
Yes.
Did you review all those items?
Yes, I did.
And do you feel comfortable sort of describing to us in a summary fashion the nature of the case, the investigation, and the arrest of Mr. Valerio?
Yes, I can do that.
Your Honor, may we have a sidebar?
Yeah.
So that's the witness who, at this point, still remains on the stand in this case, and it sounds like he's the lead investigator, so to speak. Cathy, I got into some biographical information from him there in that particular clip. But he's been on the stand, I guess, for the rest of the day here, and he should be back when they return from lunch. He's the guy that's been putting all the photos into evidence. He's the guy that describes this shootout apparently between the police and the defendant. I guess I can't really call it a shootout. I should correct myself because they shot at him. I don't think he shot at them. Just a bit of a wild scene that this guy has eventually set up.
Yes, as a matter of fact, some of our viewers in the chat room got excited just hearing police chase because, every once in a while we have a live stream of a chopper going overhead of a police chase, and that sounds like that's what this was. And you're right, I think I also described it as a shootout, but it wasn't. It was him coming toward, the officer had gotten out of his car and grabbed his shotgun, and Valerio was headed toward him with his car. So as we know, a car is a deadly weapon, and that's why the officer shot at him. But that's the lead detective that's testifying now, and he just started cross-examination before they broke for the lunch hour. So I believe the defense attorney told the judge he had about another 30 minutes left with him when they get back.
Yeah, I mean, bottom line is lots of stuff that had to be gone over this morning, not only in regards to the testimony, but I know that there was a discussion not long after this witness sat down over the aggravating factors necessary under the law for this to remain a death penalty conviction. And I've also been, trying to go over the Nevada statutes in that area myself. The jury has to basically look at aggravating factors and then mitigating circumstances and try to figure out, okay, was this a particularly aggravated crime, or were some things done by the defendant that would mitigate a sentence? There's a couple of really interesting procedural issues. So apparently if the jury hangs on a death penalty decision, if this is a hung jury on this penalty phase, the judge can go in and say it's life in prison. Okay.
Yes.
So I found that really interesting because if I were a defense attorney, I'd be throwing a fit about that rule.
Well, that's the default. See, the jury decides the life versus death, and if they're not unanimous, it defaults to life because he's guilty of first-degree murder.
He is, but there's more than two sentences though, which makes it interesting. There's a couple different versions of it, and I've got to go back and reread the statute because I read it yesterday and I didn't have my notes prepared as I should have, so you can chastise me for that, Cathy. But, there's a couple of different versions of the sentence as I remember it, and I just thought it was interesting that, okay, well, so the default is, some version of the life in prison, and there are a couple of different flavors of it that a judge could choose from or a jury could choose from if the jury so saw fit. I just think that that's really an interesting default, that if there is a hung jury, it automatically goes to one of the multiple versions of the penalty phase of the statute. So, that's going on, and I'm still going through the aggravating and the mitigating circumstances here, but I haven't heard any testimony of anything that could be perceived yet as mitigating in this case.
Well, we're not there yet, right? So we just started with the prosecution side. The mitigating is going to come up on the defense side. For the aggravating today, they went right at the heart of those stab wounds. That's why that the prosecutor was pointing out the multiple stab wounds that looked to have happened with no fight back from Karen Blackwell, meaning overkill maybe, and that's the aggravating. That's part of the aggravating that they're going to try and go at with the jury is 45 stab wounds. Really, this case is so interesting to me. I mean, there's a lot of things that are interesting about this case. Let's just talk about that it was 1986. And we're not used to seeing cases that old, so that part is also interesting. But the fact that usually 45 stab wounds is like heat of passion, right? It's like very personal. It's like someone couldn't stop themselves. And, she was a prostitute he hired. Now, I guess he saw her on multiple occasions, but it still seems so odd to have that much like anger come out in 45 stab wounds, apparently with a lot of them happening when she's not giving any kind of a fight.
Yeah, I don't know. I'm still waiting to hear how that explanation is going to roll out here, or whether it's going to play into the aggravating and the mitigating circumstances here, because the lists in the statutes are actually pretty long here. You know, I mean, the list of aggravating factors has got to be a page and a half, you know, standard size, full of text like this. And for those following along with me, I'm at the Nevada Revised Statute 200.033. It's a lengthy list of factors. You know, if the murder was committed by someone who's already in prison, then that's an aggravating circumstance. Well, that doesn't apply here, but I got to go through these and check off which ones seem to apply and which ones don't, to see whether or not the prosecution's, you know, really got this thing in the death penalty area under the law.
Right. And trial watchers are very familiar with a case out of Arizona, the Jodi Arias case, and where that death penalty phase had to be retried. Now, that was retried for a different reason. Arizona is very, very strange in their law when it comes to the death penalty. If a jury cannot come to unanimous decision, the state gets another try at the death penalty with a whole new jury. That's why that was a second penalty phase with the new jury, which you know, that's a debate for another day, that you can even do that, but that's what Arizona does. But the people that are familiar, I think that people that are watching this program are most familiar with a retrial of a penalty phase because of that case. And in that case, both sides agreed on which were mitigating and which were aggravating factors. They had specific ones, and they were listed out. Now, we haven't seen that in this case. We didn't see, quite frankly, we haven't seen a lot as those of us that were investigating this and researching this beforehand. The case is so old. You know, we're talking 30 plus years. So I don't know what the aggravating and mitigating factors were that were agreed upon originally, and if that's different now. And hopefully we'll get that information.
Yeah, I'm curious, because one thing I have not gotten into is whether or not the law that was on the books in 1986, or whether the current law is the one that they're following, because there are sometimes reasons why you can't try somebody on the new version of it. You've got to go back to the old version, and I've long since forgotten all of the specific reasons why they might have to go back. But
I would imagine it's whatever was in place at the time of because that also happened. I just, you know, look, I'm way too familiar with the Jodi Arias case. That's why I keep referencing back that I was very heavily entrenched in that case. But in that case, there was the same thing. There was a statute change like a year after the murder happened, after she killed Travis, but it didn't apply to her.
Sometimes it has to do with sometimes it has to do with whether it's procedural or whether it's substantive as well. So, you know, if all of a sudden a new crime is committed, well, that's constitutionally, you can't be tried for a crime that's defined after you've done the act. That's unconstitutional. So procedurally, though, a lot of times they'll use new procedural rules in one of these particular cases. But, you know, it's kind of interesting here, because the list of aggravating factors is about a page long under the statute, and the mitigating factors are just about a paragraph. So there are a lot more ways that a crime can be aggravated than it can be mitigated.
Right. I'm hoping and assuming that we are going to hear something from Karen Blackwell's family members, from the victim's family. Something that, you know, it hit me today. Just as we report things, we sometimes are sterilized about it because of just the nature of our jobs and what we do. And the reports from clear back then, the old news articles we pulled, a lot of it was like, he stabbed a prostitute, he killed a prostitute, and not giving her much of any other identity except that. And today they showed the picture to the jury of her and a husband and a little girl, it looks like a girl, a little child, together in some kind of family photo. And that brought it home to me that, you know, she's a person, she's a mother, she was a mother to someone, and she mattered, and she's not just a prostitute that was killed, that she had a name and she had a family. I don't know at the time if they were together, but she definitely had a child. So I'm assuming we will hear that, because that goes to that victim impact statements go in the sentencing phase as well.
Yes, and that'll be interesting to hear and look at how the societal recognition probably has changed with the times in its own sense. I want to go back and listen to some more of the testimony from earlier today because they should be back from their lunch break in about 15 minutes. I'm going to go back to James Visera, who is on the stand this morning, or I should say this afternoon here on the East Coast, and should be back on the stand when we return from lunch.
And then he said he made notifications to a supervisor and then called G units.
That's
what he was
correct.
talking about?
Yes, that's exactly what occurred. He made that notification via radio to the supervisor, and then that supervisor would contact dispatch requesting that G units or general assignment units respond to that location for that preliminary look at to determine if this is a crime where homicide should be called out.
And is that a standard practice that happened at Metro, happened for some period of time after 1986?
Yes, I believe it happens to this day.
So after the G units get there, the general assignment detectives, you weren't one of the general assignment detectives that responded to this call.
No, I was not. I worked a later shift on that occasion.
After the general assignment units got there, did they draw a conclusion as to needing other services?
Yes.
And what did they do?
They determined that they had what appeared to be a human being inside the vehicle that Officer Stubbs had located. And based on that, right there, they considered it a possibility of foul play and contacted the on-duty homicide detectives that would respond on that date.
And does homicide, when they get there, do they take over the investigation?
Yes.
Now, when you have a crime scene such as this, are there other units that are called out to process it?
Yes, these are our crime scene investigators that come out. They work in conjunction and at the direction of the homicide detectives to take responsibility for the scene and for the victim.
This particular vehicle, was it towed to be processed?
Yes.
And where does it go?
On this occasion, it was determined that the victims should remain in the vehicle, and the vehicle was towed to the crime lab directly from the location.
And then once that happens, do the homicide detective or a homicide detective remain at the crime lab with the crime scene analysis as they process this vehicle?
Right. Typically, there's a detective that would remain at the scene after the vehicle is removed to look for any type of evidence that might be around the vehicle. And then another homicide detective would go with the vehicle. There's always someone with the vehicle all the way to the lab.
Now, have you had an opportunity to see all the pictures of the processing of the vehicle at the lab, but in particular, the ones that were admitted in this particular case?
Yes.
Okay, approach Judge.
Go ahead.
I'm going to show you what's been marked as state's proposed exhibits 2, 3, and 4, and I would note for the record they were admitted as well during the guilt phase under the same number, 2, 3, and 4.
You have these, right, Mr. Harrison?
Yes, Your Honor.
Okay, go ahead.
Do those appear to be photographs taken at the crime lab of the processing of this blue transit?
Yes.
Move to admit 2, 3, and 4 for purposes of this hearing.
Any objection?
I just need to look one more time. Will you?
Sure.
Yeah. Could I ask a question on board there? Mr. Vaquero, these three photographs, are these the photographs that you've seen in reviewing the files?
Certainly in reviewing the files, but I don't know if I saw those on an earlier proceeding related to this matter.
All right, well, then let me even back it up. You did not see the events depicted in these photographs personally?
I wasn't present in the crime lab, no.
So these are just photographs that you, when you went and reviewed at a later date the file, these were photographs that were in there?
That's correct.
So you're not saying that you ever saw any of this at the time?
That's correct.
Okay. Then I have no objection to
All right.
that limitation, well, with the limitation the court has placed on hearsay.
All right, go ahead.
So I'm going to put up for you State's Exhibit number
Yeah,
2.
There'll be a minute. Let me just, instead of go ahead, let me just make formally for the record, there'll be a minute.
Thank you.
Can I just run up here and do it, so we don't have to go back there? Just one clarification I want.
You want to talk to me?
Yes, without having to do it. Don't worry, I'm not going to hurt you.
All right, no. Come on, all right.
So there's some preliminary testimony in the case against John Valerio. Again, it's a penalty phase because under the law, he's already been adjudicated as guilty. That came 19 years ago, and or more than that. You know, this case going all the way back when, Cathy, to 1986. So that's when the crime happened. He was convicted 2 years after the crime. And now we've got to go back and redo this penalty phase because of the overturning of the original penalty phase decision. A lot of appeals courts are really careful about language in these penalty phases of death penalty trials because the ultimate issue is at stake. It's the life of a human being. And there's an issue if the language that the jury has to grapple with is too vague, and that's the issue that they had here in the first case.
Yeah, and well, look, that is important. When you're putting someone to death, we need to make sure everything was done correctly. And this all came down to one thing in that jury instruction, right?
Yeah, there's one particular set of language in there that's vague, and then the other sections they said were not vague. And you know, there's a big issue as to the dissent raised on appeal is saying, well, wait a minute, you know, maybe the jury could have found this in the other elements of it, but there's not any evidence that they did or didn't. You know, I think this explains ultimately why these days we oftentimes have jury verdict forms that are ridiculously precise, rather than just, you know, death penalty, life in prison without parole, life in prison with the possibility of parole. You know, now, and we see this especially in Nevada, not surprisingly, these really, really, really precise verdict forms. You know, this is the battery for when this happened. This is for this punch. This is for that punch. We saw that in the War Machine case. And I can see why they do it, because if one of the words in the jury instruction is declared unconstitutional, then they don't need to retry the case. They can go back and say, oh, well, they also found these factors as well. Those are fine. The judgment stands.
Yeah, you know, we talk about how, as we watch trials, that some of the most tedious thing we watch is the jury instructions. When the judge reads the jury instructions, or prior to that, when the attorneys and the judge are going over what to put in jury instructions, which actually I like that part. But the reading of the jury instructions can get so tedious that we all kind of go, oh, is this still going on? Every word is important in there.
Yeah, exactly.
Sometimes an and or an or can reverse a case. Every single word is important, and we don't necessarily realize that until we're reminded when a case like this comes up.
No, you're 100% correct, Cathy, and I'm just, you know, reaching for my pen here to start going through some of this. The issue in the original case was the following language. The question for the death penalty jury back in the 1980s was, did the case involve torture, depravity of mind, or mutilation? They had to examine those three things, okay? Three things. The Ninth Circuit ruled that the depravity of mind standard was too vague. What is a depraved mind? Okay, well, torture is really clear and mutilation's really clear. And one thing that the dissent said is, you know, and I'm quoting again here, any rational fact finder could find that stabbing the victim 45 times in clusters of 8 on the head, neck, and breasts and elsewhere was murder with either torture or serious physical abuse. Okay, so if the jury form had 3 boxes, do you find torture? Check. Serious physical abuse, mutilation, check. Depravity of mind, check. Well, if depravity of mind falls off the wayside, then the original 2 would stand. At least I'm assuming. I really wish I had the verdict sheet in the original case in front of me, because I would be able to clear this issue up myself, you know, as to see whether or not that was really the issue the first time around. If all the jury did the first time around is just check death penalty without some evidence on the record as to how they got there, then no wonder the case was overturned.
Right. Yeah, exactly. I was just quickly trying to pull that up really quickly, the decision. Well, I don't want to just have dead air time while I'm reading really quickly, because something triggered my memory while you were reading that about thoughts I had when we first got this case, and about it being overturned for this very narrow reason. All right, I don't have it. Anyway, we'll talk about that on the next segment.
Yeah.
However, but that, it goes back to the whole reason the defense went and took this up as far as they did is this one little part of these jury instructions, which turns out to be a huge part, but they're saying of those three things, the one thing that shouldn't have been part of it. That shouldn't have been something they were deciding on when they decided life or death, and that shouldn't have been in there. And so that's the whole reason why we're sitting here. Here's the other interesting thing that many people are asking me about is, they overturned this in 2002, right? So now it's 2017. This case has been back and forth and back and forth and back and forth. He also tried to get a new guilt phase. He tried to get his conviction thrown out and tried to get a new guilt phase. So that put things on hold for a while. But man, the victim's family in this case has just got to be, come on, let's get this done and just get it done. I mean, I don't know how they're feeling, if they're just like, give him life or give him death. But we're so done with this. But this has been going on 15 years ago. That was reversed.
Yeah, and there's another thing that just sizzled me in this particular case. Okay, so look, the Supreme Court said that this depravity of mind standard had to go. And this happens a lot. Supreme Court says this standard can't stay in the law books. It took the Nevada legislature 15 years to catch up with what the Supreme Court said and actually remove it. So it's like, what's going on with that? Supreme Court says something, this is the law of the land. They're the ones that get to decide that by virtue of education and being selected to that court. Final say, bottom line, states read the decisions and actually do what they say, because otherwise you're just going to be spinning your wheels in cases like this. So I really wish that, I don't know if it would have saved the issue in the original one. I've got to go count what was said and when and by whom and where and all this, that, and the other thing. So, but that oftentimes is a reason for spinning wheels in state levels about these issues.
Yeah, I know. Things can take so long in our justice system. And I understand on one hand why sometimes they should take so long, because we have someone's life in our hand. On the other hand, it's like the saying is true. The wheels of justice are so slow. Things, this case, 30-something years. Now, if they had found like new DNA and, he could possibly be innocent, let's give him a new trial, then, yeah, absolutely. And I get that we're looking at the death penalty here, but it just seems like an awful long time from when the ruling came down that he deserved a new penalty phase to where we are today. That it's been taking forever.
Yeah, that's exactly where we're at. The judge has been dancing around the bench here for probably the last 3 or 4 minutes, but he has not yet taken the bench. As soon as he does, we'll bring everybody back into the case live. They're at the very tail end of what turned into about an hour lunch break here between 3:45 and 4:45 on the East Coast. It is the lunch hour there in Nevada, so that's where we are right now. I'm guessing that this witness is probably going to wrap up with more of a discussion about the bedding in the home that ultimately was found wrapped around the victim's body here. I don't know if we've gotten all of that out yet.
Yeah, we did. I did tweet a picture of that out. When
we showed the bedding, but
trunk.
I don't. Oh, they did. Okay, so that came before I was here today.
Yes, and she was wrapped in bedding. Well, it turns out that bedding came off of John Valerio's bed. That's what they found later. So that's all been testified to. He's now under cross exam. What are they going to do? He's guilty. That's not going to change. He's guilty of this. He killed her. So the defense needs to now bring out that maybe it wasn't. He's got to mitigate. So the defense needs to probably focus more on what the prosecutor was saying about the stab wounds, I would assume. But that's where we are now as cross-examination.
That's where we're at. So, we're hoping things pick up very, very shortly here. In the meantime, I want to go and play another clip from this morning. And as it usually goes. As soon as we go do that, they come back into open session, so we may have to break out of it a little bit early. But let's continue reviewing the testimony from the retired detective who's been on the stand.